name's Dave Siegel. Thanks for joining us today, and welcome to Legal Action. Today we're going to be talking about the Bankruptcy Code. The bankruptcy laws were revised almost 3 years ago. October 17 of 2005 is when it took place, and they called the new act the Bankruptcy Abuse Prevention and Consumer Protection Act. Personally, I don't see the Consumer Protection Act part of it, but I do see the Bankruptcy Abuse Prevention part very prevalent. Jesse Barrientos is joining me today as my co-host. Jesse, welcome.
Thanks, Dave.
And we're going to be talking about the different chapters and provisions of the Bankruptcy Code and how they relate to whether you can file bankruptcy today, how the process works, and how you find your way out of debt under this new Bankruptcy Act. Jesse, welcome again to the show.
Thanks, Dave. Hey, just for the folks at home, what is bankruptcy? I'm sure these days people know what it is, but basically, just generally, what is bankruptcy, the concept of bankruptcy?
Well, bankruptcy is a way to either get a fresh start or to reorganize your debt. It's for people who don't have the ability to repay their debt, and the federal government has put in this act to give people a second chance, a new lease on life, at least financially. And that could either be done through Chapter 7, which is a fresh start, when a person does not have significant assets and a lot of unsecured debt, or if a person has a lot of assets, they're able to reorganize and repay the creditors over a 3 to 5 year period.
Well, is it a second chance, or a second, a third, a fourth, and a fifth?
It could be a chance every 8 years, Jesse.
For which chapter?
Chapter 7.
Okay.
So you can get a fresh start. You can wipe the slate clean every 8 years, except for certain debts that never are eliminated in a Chapter 7.
Like what kind of debts would never be eliminated? Recent
taxes, parking tickets, child support, alimony, student loans, debts incurred by fraud, personal injuries incurred from DUI driving. So there are certain debts that are not eliminated, but I'm talking about the general debts of medical bills, credit cards, personal loans, utility bills. Those are eliminated into Chapter 7 easily.
You can get rid of all those. Well, let's talk a little bit more about a Chapter 7. You said that's really a fresh start. And so how is it that I would be a candidate for Chapter 7? What would be the first thing I would do if I came into your office and I told you, hey, I need a Chapter 7?
Well, the first thing I would want to determine is what sort of debt do you have? Is it the type of debt that can be eliminated? So if you came to see me and all you have is a recent tax debt of $50,000 from last year, I would tell you that Chapter 7 Fresh Start is not the chapter for you. So once I know what your debt is, I'm then going to look at your assets and your income. If you have significant assets, you're not going to qualify for Chapter 7 either, or if you do file that case, you're going to give up some of your assets in exchange for that fresh start. And the third thing, I'm going to make sure what your income is, because if you're making above the median and you don't pass this technical means test, in other words, having the ability to not pay your debt would make you qualify. If you make too much money, you're not going to qualify, and you're going to be forced out of a Chapter 7.
Well, let's talk about a couple of those things. You brought up a few kind of interesting things. I always thought that there were exemptions that I would have, that even though that I had some kind of equity or something, that or a car or whatever, or a little bit of money in the bank, or a pension or anything like that, that wouldn't be subject to creditors.
That's true. You don't have to be penniless to file a Chapter 7 bankruptcy, but you can't have significant assets. And here's what I mean by that. Let's talk about real estate, your home. You can protect as an individual up to $15,000 worth of equity in that home. Now, equity is the ownership portion. So if the house is worth $100,000 and you owe $80,000 on the mortgage, your equity, your ownership position in that real estate is $20,000. And I can protect up to $15,000.
Well, let me ask you this. Suppose, okay, it's in my wife's name too. It's in both of our names.
Okay.
So, is that, does she get a credit for that too? Does she have to file as well?
Well, your wife does not have to file. Maybe she doesn't have any debt in her name, and she is given credit for her 1/2 interest in that house. So in the example that I gave, if the house is worth $100,000, your wife is entitled to $50,000 if you're held as joint tenancies on the property. Therefore, the equity is even less because you've already given up her 1/2 interest.
So her 15, and then it comes to mine, so we take that into consideration as well.
You're down to 10 at that point, and 10 is easily protectable under the Illinois exemption laws.
A lot of people want to, save their home. That's a lot of things that why they file a bankruptcy. So in a Chapter 7, those are some of the questions that people have. Can I still file a Chapter 7 and keep my home as well? I mean, you talked about the exemptions and the equity deal there, but
right. Well, the second prong is: are you up to date on your home? Do you have the ability to make that mortgage payment going forward? If not, you're not going to be able to keep the home after a bankruptcy.
What if I'm a little behind? What if I'm 2 months behind?
Well, you're going to have to catch up, because if you fall too far behind, you're going to go into default, and the mortgage company is going to turn it over to their attorneys and start a foreclosure proceeding. So you can be a little bit behind, but you're going to have to find a means to get caught up. Right now, the finance companies are a little bit lenient. They're willing to work out things with people. There's some loan modifications that are happening, but in general, if you can't make your current mortgage payment going forward, you're probably going to lose the home.
So you mean that my, okay, let's say I can keep it current now, but I'm that 2 months or 3 months behind. You mean I can't get that discharged?
Oh, no, no. Real estate and a mortgage is secured. It's secured property.
Okay.
So if you don't make that mortgage payment, they can take the house through a lengthy foreclosure proceeding.
What would be another example of a secured debt?
A vehicle. A vehicle.
So the same thing would apply to that? So if I was maybe just behind one payment and I filed my Chapter 7 bankruptcy, then I'd still have to pay that back?
Well, you'd have to get current with your obligation. There's something called a reaffirmation agreement, which pertains typically to vehicles, whereby after you file a Chapter 7 bankruptcy, you agree to re-sign the obligation to pay for that vehicle. So you put yourself back on the hook for the vehicle. Now, the finance company is typically not going to offer you that right if you're not current. They're going to look to repossess the vehicle. So you're going to have to become current to put yourself back on the hook for that vehicle going forward.
So I'm going to have to make myself current before I file the bankruptcy? Or during, or?
Pretty much during the process. They're going to give you some leeway to get caught up. But remember, if you're filing a Chapter 7 bankruptcy and you've eliminated your credit cards, your medical bills, and your personal loans, and possibly your past due utilities, you should have the ability to make your car payment. If not, you're in a car you can't afford, and I would recommend that you surrender it at that point.
We'll talk about that in a minute. So what you're saying essentially then is that I'll have a little bit of an opportunity even after it's filed, because now I'm not going to have those other debts to pay it and to get current on it.
That's true. And hopefully you're making some adjustments in your budget after you've gone through the court-required credit counseling and budget analysis procedure. Hopefully you're realizing that you can't spend $800 on food for a family of 2. You have to cut back on some of the steak and lobster that you partake in, Jesse.
That's what I had yesterday, actually, Dave. But let me ask you this. Well, suppose then that I owe $25,000 on the car, and it's only worth $8,000, and I don't want the car anymore.
Okay, so you're upside down with the vehicle.
Exactly.
I would recommend that you surrender that vehicle and get out of the debt. Or you can try and find a lender who will secure you a loan for the fair market value of that vehicle, and you could strip the original finance company of the underlying debt. In other words, you get a new loan for what the market value of the vehicle is, and you redeem the vehicle, which is under 722 of the Bankruptcy Code.
So, and just so that I understand, what you're saying is that if it's only worth $8,000, but I owe $25,000 on it, and I can get that loan, that the bankruptcy court is going to allow me just to pay $8,000 and keep it for that? Do I have to pay it all in lump sum, or how does that work?
Well, you have to bring a special motion before the bankruptcy court. You will already have the approval from the second finance company, and yes, the second finance company will pay off the first immediately upon approval.
Just that amount, just that $8,000 amount?
The fair market value. But here's where we get into something.
Okay.
The first finance company, who is owed the $20,000 and change, is going to dispute the value of the vehicle. So you might have to go to a hearing on what the vehicle is actually worth. Okay, and that's done through either a Blue Book or an appraiser or several different estimates. But the court is going to want to hear testimony if there's a dispute as to the real market value.
Wow, it's really incredible. I was just thinking, since we want the folks at home to kind of know a little bit, what is the first thing that we do, that you do when you're going to file the bankruptcy? Let's just say it's Chapter 7 now. I've come in, you've determined that I can file a Chapter 7, right? And so what do you do from there? Are there any requirements that I need to do other than fill out the petition and sign it and give it to you?
Yeah, there are several requirements, but the first thing before we get to that, I would advise the client to stop incurring the credit. Stop using the credit cards. Don't make any major purchases. Don't take any cash advances. Don't take out any personal loans close to filing the bankruptcy, because it could be presumed to be a fraudulent maneuver.
How long before? I mean, let's just say, hey, all of a sudden, here I am. I just used my credit card to buy groceries for my children, and now I just realize, hey, this is it. I can't do it anymore. So I'm gonna have to pay that back that I charged back in this couple weeks ago.
The code talks about major purchases within 70 days of filing, presumed to be fraudulent. That presumption could be rebutted. I basically tell my clients to wait at least 90 days before filing and don't use the cards anymore. You don't want to put this presumption in front of the court where the creditor can come in and try and hold you responsible for those recent payments.
Because then it won't be discharged.
Right. In many cases, though, especially with credit card debt, the credit cards are already terminated, the clients don't have the ability to incur any more credit, and they've been maxed out and closed for some time. So that's a safer option when they don't have the ability to run up any additional credit. Because running up credit is a definite no-no under the Bankruptcy Code. Let's talk about the requirements you asked about. Mm-hmm. Well, there's several. First of all, you must take a credit counseling session, which is a 1-hour session within 180 days of filing. So you must submit to that before a case can be filed.
Is there a cost for that?
Yes. The typical cost is $50. There are some groups that are doing it for less than that. Anywhere from $25 to $50 is the cost, and a couple can do it together for the same $50
for the same 50
fee.
And we can, I mean, is it something that you go in person, or is it something I can do on the phone or on the internet, on the computer? How does that work?
All three. You can do it on the internet, takes about an hour. You can do it over the telephone, takes a little bit longer than that. Or you can do it in person if you find a place close. But whichever method you do, you have to bring in information concerning your income, your expenses, and your debt.
Is that part of the new reform?
It is.
Okay.
Yes, I think the goal was, or Congress's intent was, that some people would go through this credit counseling and decide not to file a bankruptcy, and that they would enter into some kind of debt management repayment program with their creditors. In reality, most people who are doing this are just doing the credit counseling as a means to an end to file Chapter 7, and they're not being diverted into a debt management program.
So it's one more hoop to jump through is all it is?
It's the first hoop.
First hoop. Well, okay. So, all right, what's the second hoop?
The second hoop is they must have filed their most recent federal taxes. Now, I thought this was really going to trip people up. I thought there were many people who didn't file for their taxes, and they'd have to go see an accountant and get this all done. And remarkably, I'm seeing people who have filed their taxes. So I'm a little bit surprised by that. So we can get over that obstacle pretty easily. Most people have filed.
What happens if someone hasn't filed?
They need to file.
So they need to find an accountant,
right,
and go back and do their
right. Unless they have a certain level of income where they weren't required to file.
Okay.
Under the IRS code. Okay, and I don't know what those figures is. I'm not
Sure.
an accountant, but if they can get something showing that they didn't need to file, that would be sufficient.
Okay. So then, the next hoop would be what?
The next hoop or hurdle?
Right.
Okay. Pay advices. However the person was paid, whether it be from a job, Social Security, retirement benefits, they have to show the proof of their income for at least 2 months before the case is filed.
So it's directly, so if I come in right now and I give you all my 60 days of payment advices, but you don't file for 2 months, I have to give you some more payment advices.
Right. I'm going to be calling you just before we file the case saying we don't have your most recent 2 months worth. And you're going to say, but I gave you my pay advices. And I'm going to have to explain to you again, it's the most recent 2 months just before the case is filed. And just recently, Jesse, the U.S. trustee is also requiring, not just the trustee who hears your case, but
Sure.
the U.S. trustee, the head of the trustees, is requiring that the 60 days of pay advices be emailed to them for every Chapter 7 bankruptcy case filed after June 27th.
Goes to the local trustee and to the U.S. trustee.
Yes,
so
the U.S.
you said
trustee
both
is
places.
providing oversight. In my opinion, I think they weren't pleased 100% with the way the panel trustees were looking at the pay advices, or they're just looking at one other element to scrutinize the petition and see if someone is doing something fraudulent.
Sure. Well, let me ask, let's just go back for a second. You know, in a Chapter 7, I need to provide you with how many tax returns?
Chapter 7, it's the most recent year. So 1 year.
So last year. What about a Chapter 13? And we'll talk about that in just a little bit.
Chapter 13 is 4 years of tax returns.
4 years of tax returns.
Yeah,
Okay.
It's a little different.
All right. So now you got the payment advices and everything else. What else do we need to do?
Well, I have to have a petition completed with the client's signature. I have to have all the information concerning their income, their assets, their debts, and it has to be signed and verified, and it has to be returned to me. And at that point, if all the other pre-bankruptcy requirements are satisfied, I could file it with the court and get a case number, and I can do that all electronically through the internet these days.
And, okay, now let's assume that process worked out, there's no problem, and now it's been filed. Now, what happens? What kind of protection do I get? How do I stop these calls from happening?
Okay.
Because all the creditors are calling me. So what's to prevent them from continuing to call me or
You're
knocking
tired
at
of
my
their
door?
calls?
I'm tired of their calls.
You're
So what
tired of the
happens
computer
next?
calling you every hour
tired of the
from
computer.
Discover Card?
Right, exactly.
Okay. What you can do is once your case is filed, you have a case number, you have a date of filing, you have a creation of what's called an automatic stay, which is a big stop sign that goes out to the creditors, and they're prohibited from taking certain actions against you. And one of those would be making collection calls or trying to collect on a debt.
What happens, well, first, this applies to Chapter 13 as well?
Yes, it does.
And what happens then if I just get that person who just keeps on calling me, and even though they have received notice?
Right. Well, first of all, you should have been giving the attorney's name and number the minute you hired the attorney. Because even before the case is filed, you have protection under the Fair Debt Collection Practices Act immediately upon hiring an attorney, as long as you provide the name and number of your attorney to that debt collector.
So if I do that, even though you haven't technically filed for me yet, then what, they're not supposed to call me?
That's right. And they could be sued for violation of the Fair Debt Collection Practices Act, which I believe carries a penalty of $1,000 per violation. Now, we don't see a lot of those cases because most of the time the creditors are pretty good about calling the attorney and verifying whether or not that client has in fact retained a law firm to file a bankruptcy on their behalf. They don't want to be harassing people if they know they have an attorney and they know they're going to be filing a bankruptcy, because it is a clear, simple violation of that act, which could set them up for sanctions.
Okay, so now after we have this and we have the automatic stay, am I done? Is my bankruptcy complete? Do I have to go to court? Do I appear before anybody? What's the next thing that
the filing of the case just gets it started?
Okay.
At that point, the clerk of the U.S. Bankruptcy Court is going to distribute a notice of filing to all the people listed in your petition. So they'll get a formal notice about 7 to 10 days after filing saying that you filed, and they're prohibited from contacting you. You then must appear at a 341 meeting of creditors, and that's 341, Section 341 of the Bankruptcy Code, which basically says you need to appear before the trustee and answer yes/no questions under oath based on the documents filed in your case.
What kind of questions do they ask typically?
Well, they're going to ask information about your income, about your assets. They're going to ask about your employment. They're going to ask whether you have real estate. Did you transfer any property? Did you give away anything for less than its fair market value? Do you expect to inherit any money in the next 6 months? Can you sue anybody for any reason? They're basically looking for assets.
So what happens if I do have this? And by the way, this applies across the board to Chapter 13 as well as Chapter 7.
In terms of the 341 meeting of creditors, yes, but it's different in terms of which chapter you're filing as to what's actually going to happen for what the trustee uncovers. For example, in Chapter 7, you don't want to have any assets because the trustee is going to take those assets. In Chapter 13, you retain your assets because you're repaying your creditors over a 3 to 5 year period.
So in this Chapter 7, if I have anything that's of value that's not covered by the exemptions that we talked about earlier, they're going to take it?
Well, it depends on the asset. It depends on how much over the exemption amount you are. The real estate example, we talked about $20,000 worth of equity in the property, and the state allows you to protect $15,000. We also have to factor in what it's going to cost for the trustee to sell it. 6% commission, closing costs. Would there be anything left? No.
Right.
So in our example, technically you're over the $15,000 at $20,000, but the property's protected because the trustee's not going to be able to recover anything for the benefit of the creditors.
For that amount of money.
But if it was $50,000 or even $60,000 or anything higher, the trustee is going to look into putting that asset on the market and paying you just your exemption amount of $15,000 and using the rest to pay your creditors. So that would be a mistake if you filed a bankruptcy not knowing what the value of your house was.
That's why it's important to find that out. Now, after that meeting for our Chapter 7, now we're done, right? I don't have to do anything else. I can relax. There's nothing, no other requirements that I have to do as the person filing the petition.
Well, there is one more thing. Remember we went to credit counseling at the beginning before the case was filed?
Oh, that's all done. Yeah, we did that. I learned. They
learned you needed a
things.
bankruptcy.
They learned I needed bankruptcy, right.
Okay. Well, now you need to submit yourself to a 2-hour financial management class.
2 hours?
2 hours.
Can I do that over the internet?
You can.
Over the telephone?
You can.
And I can do that in person?
Sure.
Is there a charge for that?
Yes.
Same charge?
Roughly $25 to $50.
And if
but you're going to learn so much about financial management, Jesse, that you're never going to have a problem with debt in your life again.
Never ever.
Right. In fact, you might even be able to host a show on cable that will give financial advice.
Well, you know,
I'm being facetious.
I'll see you in 8 years. Right? You said
right.
Another
8 years in a day. I've seen the class. It is helpful
Sure.
for some people. I don't want to knock it completely, but there are certain questions that talk about, you know, what's a better interest rate if you're carrying a balance on a credit card, 3% or 30%? There's some stuff like that.
I mean, I would think.
Yeah. The goal, once again, is to educate people. This is the government believing that they can educate people in a 2-hour class so that they never fall victim to having to file bankruptcy again and that they repay their creditors.
Well, let me ask you, because we've gone through the Chapter 7 deal here too, and you said there were just some differences with the Chapter 13. You said that Chapter 13 is not something where it's something where I keep my assets and I just pay, try to pay some of those creditors back.
Chapter 13 is basically bill consolidation through the court. It allows you to keep all the property that you want to keep as long as you continue to pay for it, and reorganize the rest of your debt. So let's say you're behind on your mortgage. The Chapter 13 would allow you to pay that part that you're behind over the next 3 to 5 years.
So I can keep that, other than the other example, in the Chapter 7 example, you said it's too bad. If I don't catch it up, then I'm out of luck.
That's right. Chapter 13 is also known as a home saver case. It stops a foreclosure immediately.
So what if there's a sheriff's sale tomorrow?
You better file today.
Okay, and it'll stop the sheriff's sale?
Or if you file tomorrow, you better file before the sheriff's sale actually takes place.
Before the hammer slams down.
That's right. Because once
and
the
it'll
sheriff's
stop
sale,
it? I mean, how does it, does somebody go there?
It'll either stop it if you go there and show them proof, or you can get them proof via fax or by phone. Or if you don't get them proof, they're not going to go forward with the approval of the sale once they become aware of the bankruptcy.
Okay.
So as long as you beat the sale date in time, you're going to at least have a fair shake of doing a Chapter 13 and reorganizing. It's no guarantee. You still have to be able to make all your payments, not only your Chapter 13 payment, which is your consolidated payment, but you need to make your regular mortgage payment, first, second, or third, however many you have, timely, again, after filing. Oh, sure, sure.
So it sounds like kind of what you're saying is that after certain allowable expenses, any money that's left, is that how that works? I mean, how do we determine the amount that I'm going to pay? Is it
whatever your disposable income is, whatever the court determines that you have available per month, that has to be submitted to your Chapter 13 plan to go towards your creditors. You're not able to say, well, the budget is showing $500 available, I'm only going to pay $100 each month.
So I've got to pay the whole $500.
Right.
So I'm going to be living on a tight budget.
Definitely.
What happens if after my allowable expenses, there's nothing left?
There should be nothing left.
No, I mean to fund the plan.
Oh, you don't have the ability to repay anything to the Chapter 13?
After we take what I'm allowed for, my mortgage and for the car and for food and for the utilities and insurance and and all this other stuff and the car, whatever. Okay. I have nothing left.
You're either going to have to increase your income. I don't think you're working a part-time job, are you?
Well, no. Wow. Okay. So you have to increase your income to do that.
Well, if you really want to save your home, you might have to take in a tenant. You might have to get some family assistance, or you might have to put the house up for sale because Chapter 13 is not going to be feasible.
I'm not going to be able to do it.
You're not going to be able to do it. It's straight math here.
Well, what if I have $100 available a month?
Well, that's a good question. Then it's going to be an analysis of whether that $100 a month is going to be enough to repay all or a portion of your debt over the next 36 to 60 months.
Is there something, are there preferences in terms of who gets paid first and who doesn't?
Yeah, well, preferences are more common in a Chapter 7 if you're talking about preferring one creditor over another. There is a hierarchy, if that's what you're talking about in Chapter 13, as to who gets paid first. And actually, child support, domestic support obligations get paid first, and then attorney's fees, and then secured creditors. The very last person who gets paid is an unsecured creditor, and they sometimes don't get paid anything over 10 cents on the dollar, and that would be credit cards, medical bills, personal loans, utilities. Is
that the limit? Can they go below 10%?
Technically they can. We don't see that in this jurisdiction very often.
So
if you want to get your case approved, you should be providing at least 10% to the unsecured creditors.
And what do you mean about approved? We talked earlier about a 341 meeting of creditors with the Chapter 7. So what's this approval that you're talking about?
Right. Chapter 13 is a little different. There's going to be a Chapter 13 standing trustee appointed to oversee the case. That's the person that actually collects the proceeds and disperses it to the creditors over time. That trustee is going to step up at a confirmation hearing and either recommend or not recommend that your payment plan be approved to the court. So you've got to satisfy that trustee that you're complying with the provisions of the code and putting all of your disposable income towards the repayment of your debt.
Well, what kind of things they asked me at the 341 meeting for Chapter 13 as opposed to the 341 meeting for Chapter 7?
Well, a lot of the questions are the same, but they're really going to scrutinize the budget. They're going to look at the paycheck stubs a whole lot differently, and they're going to make sure in correlation with your debt that there's enough income to pay off the debt or the proper percentage of the debt. In Chapter 7, they don't worry about the debt.
Because it's going to be gone.
It's going to be a wipeout.
Well, what happens if I have a pension and money's coming out of my pension or coming out of my check to go into my pension at work?
Okay, it all depends. It's a 401k?
401k.
Or retirement. It depends if it's mandatory or not. If it's mandatory and it's required as part of your employment, it can continue. If it's voluntary and you're just putting it away for a rainy day for your retirement, that has to stop when you're in a Chapter 13 because you have to repay your creditors before you're able to provide for yourself through a retirement benefit. So it's a little tricky. The budget is really scrutinized.
So that's kind of the difference. That's where you're talking about where they ask a little bit more in terms of different things that they don't care about.
Yeah, there's also serious limitations on how much you can put for food, clothing, transportation. The trustee wants to make sure that you're putting all of your disposable income under the IRS standards. That's all they really allow. So there are certain limits. Again, food, you can't spend $800 for food if you're a couple for two. The court says that's over the top. And more of that money can be pulled out of your food budget and put towards your creditors.
Put someplace else. So basically with the Chapter 13, what you're saying is, hey, I'm going to have to, with whatever amount I have left, whether it's $100 or $200, I have to pay back all my secure creditors completely within 3 years or 5 years, right?
That's right.
Plus, in addition to that, at least at a minimum, 10% of the unsecured creditors.
That's right. Chapter 13 is no walk on the beach. It's difficult because you have to make your regular payment on your mortgage, and you also have to put this additional payment towards the Chapter 13 trustee, which takes care of the mortgage arrears, auto financing in full, and all of your other debt. And you got to do this consistently for 36 to 60 months.
So
that's tough.
What happens if if I have an issue or there's a problem? What happens if my income changes? Let's say I'm paying $600 and now something happened. I'm not getting overtime and I'm making $300. Am I stuck with paying the $600 to the trustee, or can I come back to you and say, hey, Dave, listen, my circumstances have changed?
Right. In certain cases, we can bring a motion to amend the plan and amend the amount that you pay per month. The one caveat here is that there has to be a certain amount paid towards your creditors. So if $600 is what was needed to make the case work at a minimum, and now you want to reduce it, it won't work. But sometimes there is room, depending on the case.
Well, then what happens then to my case?
If you can't make the payments, the trustee is going to bring a motion to dismiss it eventually.
And then what happens with all the payments I've already made?
Well, those have already been applied to your creditors to that extent, but once the case is dismissed, the creditors are free to pursue you once again. You lose your bankruptcy protection once the case is dismissed. You may have the ability to refile, which creates a whole other issue of extending the protection of the Bankruptcy Code, but you may get another crack at it.
What have you seen more prevalent, Chapter 7s or Chapter 13s, especially with the home crisis that we've seen with the foreclosures and everything else?
I'm seeing a lot of Chapter 7s where people are just walking away from their home. They're not even attempting to repay it in a Chapter 13. The reason being is these adjustable rate mortgages, when they go up, that ongoing mortgage payment has to be paid outside of the Chapter 13 plan.
Oh, say that again, because that's very important. Say that again for our viewers.
Yeah, as the interest rate goes up, if the mortgage payment goes from, let's say, $1,000 to $1,500, right, and they file a Chapter 13, they have to continue to make that $1,500 payment. So it's very difficult. A lot of people are just walking away from their homes. And that's a sign of the times, Jesse. And that covers basically Chapter 7 and Chapter 13. Okay, we've covered the Bankruptcy Code, the Bankruptcy Abuse Prevention and Consumer Protection Act. That was passed October 17 of 2005. Bankruptcy is definitely here. It's definitely available. But you got to know what you're doing. So find good counsel. We'll see you next time on Legal Action. Thanks for joining us.